and a constitutional lawyer.
Sir, Gautam Bhatt. Gautam Bhatt.
So sorry, extremely sorry, sir. Gautam Bhattji.
Bhatia.
Gautam Bhatia ji. Sorry, sir. I am extremely sorry. Gautam Bhatia ji, a very renowned constitutional lawyer and senior advocate, who has been kind enough to deliver the lecture at a very appropriate time, where there is lot of deliberations going on about the role of media in our country. And we are all happy, sir, that our Honorable Vice Chancellor of our University, Professor Dr. K.R. Venugopal, has made it very convenient for our college to organize these type of lectures, seminars, and workshops for the benefit of the student community and the academia. On behalf of Bangalore University, on behalf of University Law College and Department of Studies in Law, and all others present here, I extend a warm welcome to you, sir.
Thank you.
And also welcome our Honorable Vice Chancellor, Professor Dr. K.R. Venugopal, to this lecture series, and all other colleagues of my department, student friends, and all other who have joined across for this very erudite, learned lecture by Shri Gautam Bhatia. Over to Meghana, madam. Thank you.
Thank you, sir, for extending a warm welcome to our guests and participants for today. Before we get started, any questions on the lecture may please be posted to Ms. Hita, the co-host, and the YouTube viewers can post their questions in the comment section. We will take it up after the lecture during the question and answer segment. Media. It is one of the most and major sources of information. It also serves as a means of communication that influences people widely. Each mass medium or information and communication technology has its own regulatory authority. To analyze, discuss, and enlighten us on this issue, we have our exemplary dignitary, Shri Gautam Bhatia. I take this proud privilege to introduce the esteemed dignitary for today's lecture. Gautam Bhatia is a graduate of the National Law School of India University and the Universities of Oxford and Yale. He practiced for 4 years in Delhi and is presently pursuing the doctorate of philosophy at the University of Oxford. He is the author of Offend, Shock or Disturb Freedom of Speech under the Indian Constitution and the Transformative Constitution, which drew a lot of praises from the critics and was also shortlisted for the Hindu Literary Prize 2019 under non-fiction category. Sir, we are immensely honored to have you here and are eagerly waiting to hear from you. I request you to kindly take over, sir.
Thank you. Thank you so much for that kind introduction and for all those nice words. I mean, the topic of media regulation from a constitutional lens is actually a very broad topic, because the word media itself includes a whole range of kinds and forms of media, all of which are subjected to different legal regimes for the regulation. I thought I'd focus, at least in the beginning, on perhaps the most common understanding of media, which is the TV media, and that, as I think everyone here knows, is regulated by a 1995 law called the Cable Television Networks Regulation Act. And so what I'll do is, I thought that I'll take you through the act, some of the issues that the act raises, some of the concepts that are important to understand. And as I much prefer a conversation to talking at you, we can try and reserve more time for Q&A and discussion than just an outright lecture. So the Cable Television Networks Regulation Act was enacted in 1995, and so that act sets out a number of definitions that to do with programs with cable television, public authorities, and so on. And it requires cable television networks to be registered with the government under the Act. Now, once the cable network is registered, then it needs to follow certain rules, and that is spelled out in Section 5 of the Cable Television Network Regulation Act, which says that no person shall transmit or retransmit through a cable service any program unless such program is in conformity with the program code. So substantively, the content of regulation, that is what it is permissible to transmit and what it's not, is defined by the program code that takes the form of secondary legislation under the Cable Television Network Regulation Act, right? We'll come to the program code in a moment, but it's then also important to see that as you've all no doubt studied, there's no point in a law unless there is a method of enforcing that law. So in Chapter 5 of the Act vests in the authorized officer, which in this case means the officer appointed by the government, to prohibit transmission of certain programs in the public interest. So the authorized officer can, where they think that there has been a violation of the program code, or their program is likely to violate the program code, can prohibit its transmission, and can also then under Section 20 prohibit the operation of a whole network in the public interest, in the interests of the usual subclauses that you see in, for example, Article 19, sovereignty or integrity of India, security of India, friendly relations with foreign states, public order, decency or morality, and so on. So that, in a sense, is the scheme of the relevant part. That's the scheme of the Cable Television Network Regulation Act. So it basically, through a system of registration, requires cable TV operators to follow the program code, and then it vests the responsibility of enforcement in the first instance upon government officers by prohibiting transmission of programs or of entire television networks. Now, what does the program code itself say? The program code has it runs from subclause A to O, so it has a lot of subclauses. And if you look at the program code, you'll see that a lot of it is actually framed in very broad and wide terms. So it has, for example, prohibitions against good taste and decency, criticism of friendly countries, prohibits half truths. I'm not quite sure what half truth exactly means. So it has a range of prohibitions uh, that basically determine when a cable TV operator or network falls foul of the rules under the Act. So if you think about then the scheme that is set up by this Act, it basically goes through the following process. So that it sets out the rules, and then it, so for example, it's somewhat similar to Section 95 of the CRPC, where the initial decision to ban a book is taken by the government. So it's not that a court decides, at least in the first instance, whether or not to ban a book, but it's the government that decides. Similarly, the Cinematograph Act, which is about the regulation of films and cinema, there again you have the Film Certification Board, or the Censor Board, as it's popularly known, that decides in the first instance, whether a film can be cleared or not, what rating it has to be given, and so on. And so, similar to that, for media regulation under the Cable Television Network Act and rules, there are government officers who decide when there has been a breach of the program code, and what penalty that merits. So this scheme then raises three possible situations, three possible outcomes when we think of various possibilities. So the first is that everything works as it should be working. So where there has been a clear violation of the program code, then the authorized officer acts and prohibits transmission of a program or something within it, where there is no violation and there is no such prohibition, and so it progresses smoothly, and there is no need for courts or the judiciary to get involved. So that's when everything is working as it should. The second possibility is when the government acts wrongly, or when the government overreaches. So it wrongly finds that there has been a violation of the program code. It attempts to censor TV programs. And you would have heard about this much more in the context of film censorship, because that's what often captures public imagination. But the scheme is the same. So just like the censor board often overreaches, often substitutes its own sense of morality for applying the constitution in a similar way, authorized officers under the Cable Television Network Act often overreach and attempt to engage in censorship. So then, in that case, that decision of the government can be challenged before the judiciary, much like it can under the regime of film censorship or under the regime of book banning under the CRPC. Of course, the distinction is that under the CRPC, there is a mandatory requirement that any challenge to a ban on a book has to be heard by a full bench of the High Court of that state. So that provision is not there in the Cable Television Network Act. So in that sense, it's less protective of free speech. But there's always a possibility of a challenge that can be made to the decision of the government, and there you have a lot of precedent from the domain of film censorship that applies. So in a range of cases such as Bobby International versus Ompal Singh Hoon, which was about Bandit Queen, the film Bandit Queen, 1996 decision of the Supreme Court, or S. Rangarajan versus P. Jagjeevan Ram, which was a 1987 judgment that involved a film about reservations that was made in Tamil Nadu, where the Supreme Court famously said that in order to justify a restriction on free speech on the grounds of public order, the relationship between the speech and the anticipated disorder has to be as proximate as a spark in a powder keg. So you can't say that because people are likely to protest or people are likely to commit violence in response to a film or a media program, therefore that becomes a reason to ban or censor it. In that case, the responsibility of protecting the program, or of protecting free speech, of ensuring that there's enough, say, police presence to avoid disorder, that responsibility lies with the government. So unless there is like a spark in a powder keg, somebody's inciting a riot, inciting violence at that exact moment, anything else cannot be a ground to restrict speech. So you have this entire range of case law over many years that specifies the standards under Article 19(2) of the Constitution that have to guide the court in determining when the government has overreached in censoring, whether it's a film or a TV program, in the media. The third possibility is actually the reverse of the second possibility, which is that there is actually a program, that does violate the program code. That there is an offense under the law that's happened, but the government actually fails to act or refuses to act. So for whatever reason, the government says we are not taking action under the program code and under the act against this particular program or channel, despite the fact that the channel is breaking the law. So then one has to go to the court, but the entire process is reversed. So here the argument is not that the government has acted too zealously or has acted, in overreach, but that the government has completely failed to act at all. And of course, then a lot of questions arise. So if you're going under Article 226 or Article 32 specifically of the Constitution, then the important question then becomes that what is your locus, or what right of yours has been violated through this program that justifies you in coming to the court and claiming that action should be taken, an FIR should be registered against this TV channel or this individual, and the provisions of the act should be activated by the government. So you have to show that, at least in theory, you have to show that some right of yours has been violated, that justifies you going to court, and we'll come to that in a moment. Once the case, say you go to court and notice is issued, then there are a number of other possibilities arise, and so the first, of course, is that in this case, the government, first of all, what you're doing is you're asking the court to review the actions of the expert authority in failing to act. Now, here again, you have a range of cases that are there in the context of film censorship that have been decided over the years. So cases, for example, involving various films of Raj Kapoor, for instance, where the censor board say did not agree to censor or take out certain aspects of a film, but other people who were offended by it went to court and argued that their rights are being violated and therefore the film should be censored. So there's the standard that has been laid down by the court in a number of cases, is that the court will ordinarily defer to the decision of the expert body, but that deference is not irrebuttable. If it can be shown that the expert body, whether it is in the context of films or in the context of the media or TV, acted either outside its remit or clearly misapplied the law and thus violated constitutional rights, then in that case the court can overturn the decision of that body or that officer, and it can either remand the case back for a fresh hearing in accordance with the law that has been laid down, or it can itself decide the case and say that no case is made out for X or Y. So the court. So if you're challenging the decision of the government under the Cable Television Network Act, specifically not to act on a program that you're saying violates the law, then at first instance the court will be deferential to the judgment of the executive, unless a clear legal violation can be shown. The second issue that arises, and this is proven to be a very controversial issue, is that suppose that the program has not yet been aired, or suppose that the program is midway through being aired, and it's not finished yet. So there, not only are you asking the court in that case to issue a ruling on the actual violation of law, but pending the final judgment, because that will take some time, if to issue notice, hear the parties, decide the case, and so on, you are also asking for an injunction on that particular program from continuing to air until the main case is resolved, right? And so that raises a number of issues concerning injunctions in the context of specifically the media and of free speech. Whereas in normal circumstances, you have the famous three-pronged test for injunctions: so balance of convenience, irreparable harm, prima facie case, right? So you have the three-pronged test that is applied to injunctions. In the context of free speech, it becomes a little more complex, because if you look at the judgments of the Supreme Court and indeed free speech theory across the world, there are two or three justifications that are advanced for having a strong free speech right. One is search for truth. The second is democracy. It helps to sustain democracy, and the third is that the marketplace of ideas. This is the image that is often invoked. The marketplace of ideas cannot be interfered with unless there is very strong reason. Now, the reason why injunctions against the media and injunctions in the context of free speech are particularly problematic and require a higher standard, as has been held in a few cases, is that if the entire issue is preserving a free marketplace of ideas, then an injunction effectively prevents the thought or the idea or the message from even coming into the marketplace at all. So unlike, say, a subsequent finding that there has been a breach of law and a conviction, which then leads to punishment or whatever it might be, an injunction operates even before that piece of speech has even come into the marketplace. So it distorts the marketplace at the start. And that's why this whole idea of what in free speech theory is called prior restraint, that is restraining of speech before it is spoken on grounds that it might violate law, the threshold is very, very high. So in the famous case of Bhushan versus State of Delhi, one of the very first cases decided by the Indian Supreme Court, it was clearly held that a prior restraint, which is restraining a speech, whether written or in the media, before it's published or broadcast, it requires an extremely high threshold. You also see this playing out, for example, in defamation cases often involving the media, where if it is argued that the court should grant an injunction to a plaintiff because a certain program, certain TV channel is defaming them, and so there should be an injunction pending the final disposal of the case. The threshold that is required in law, although it isn't always followed by courts, the threshold required in law originally in common law, and then upheld by the Delhi High Court in the famous Tata Sons versus Greenpeace case, is that unless the plaintiff basically shows that the defendant has no case at all, or the defendant is almost impossible to even imagine the defendant winning even after a full trial. If that has not been made out, then the court will not injunct the speech pending decision. Of course, if it later finds that defamation has taken place, then can award heavy damages. All of that will follow, but the court will not stop the speech from happening because an allegation is that it has caused defamation. Unless, of course, as I said, it is absolutely clear that there is no chance for the defense to succeed, then the court will grant an injunction. But that's obviously very, very rare. And you can also see the case of National Stock Exchange versus Money Life, Bombay High Court case, that also endorsed this proposition. So you can see, therefore, that if someone moves court to argue that a particular media house or media channel or program is violating the program code, but no action has been taken against it by the government, as the government is required to do under sections 19 and 20 of the Cable Television Network Act, then the court should be very slow to grant an injunction, although, of course, it should hear the case in the normal course of things. Now, the last thing that I want to discuss in this context is that there's probably one exception to this general rule of there being a very high threshold for injunctions, and that exception is that of hate speech. Now, hate speech is not a concept that is defined under the Indian Constitution. It's not, you don't see the word hate speech under Article 19(2) of the Constitution. It's not there under the Indian Penal Code. So you do have Section 153A, B, and C of the IPC that talks about spreading hatred between classes, groups, and so on, which is somewhat similar, but it doesn't use the phrase hate speech. So then the question is that what exactly is hate speech? Who should it protect, and what should it prohibit? Now, the Indian Supreme Court has answered the question once in the case of Pravasi Bhalai Sangathan versus Union of India, 2014 judgment. So in that case, the court was asked to issue orders or guidelines for the general curtailment of hate speech in the context of elections. Now, the court did not issue guidelines on the basis that existing legislation was adequate to deal with the issue. But at the same time, the court also decided to explicate its understanding of hate speech laws and their place in a democratic republic committed to free speech and expression. So what the court effectively did was that it held that hate speech violates Articles 14 and 15 of the Constitution, equal protection of law and non-discrimination. Citing the Canadian judgment of Saskatchewan versus Whatcott, the court said, and I'll quote the paragraph, hate speech is an effort to marginalize individuals based on their membership in a group. Using expression that exposes the group to hatred, hate speech seeks to delegitimize group members in the eyes of the majority, reducing their social standing and acceptance within society. Hate speech, therefore, rises beyond causing distress to individual group members. It can have a societal impact. Hate speech lays the groundwork for later broad attacks on the vulnerable that can range from discrimination to ostracism, segregation, deportation, violence, and in the most extreme cases, to genocide. Hate speech also impacts a protected group's ability to respond to the substantive ideas under debate, thereby placing a serious barrier to full participation in our democracy. So this is a quote from the judgment, and the last sentence is specifically important in the context of the discussion on media regulation and injunctions, which I'll come to in a moment. But it's important to note that what the Supreme Court made clear is that the offense of hate speech is not about causing distress to an individual, but about targeting the social standing of persons qua their membership of groups in a way that opens them up to hostility, discrimination, or even violence. So these arguments are founded not upon protecting someone's feelings. It's not about causing offense or being offended or having one's feelings hurt, but upon the constitutional value of equality. And in this, the Supreme Court basically was echoing the existing state of theoretical and scholarly analysis of hate speech. For example, Jeremy Waldron, the legal philosopher, argues that hate speech damages two basic values that underlie modern democracies. The first is the value of inclusiveness. So in pluralist societies like Indian society, there are always a multiplicity of races, religions, philosophies, ways of life, and so on. We call them groups. An inclusive community is one that guarantees to each person, both as an individual and as a member of any group or groups, an assurance that that person can lead their life without facing hostility, violence, discrimination, or exclusion by society. And so Waldron argues that everyone ought to have a sense of security in the common public space that we all inhabit. And of course, this sense of security is created and cultivated through daily interactions, including through the media. And the second basic value that hate speech implicates is of dignity. Dignity means equal citizenship, an affirmation of everyone's basic social standing as a proper subject of society's protection and concern. And of course, both inclusiveness and dignity are values that stem from the basic idea of everyone being an equal moral member in society. Right? So the values underlying the prohibition of hate speech are of dignity and inclusiveness. And going back to the last line of the quote's paragraph, which I read out, that hate speech also impacts a protected group's ability to respond to the substantive ideas under debate, thereby placing a serious barrier to the full participation in society. Now, this explains why, in a hate speech case, the standard for injunctions under the Cable Television Network Regulation Act will possibly be lower than other cases. Because what hate speech does, if it effectively dehumanizes people. And so if somebody is accused through hate speech of X, Y, or Z, they're not really in a position to respond and to take part in the marketplace of ideas on equal terms. That's why equality is a very important value here. So given that then hate speech itself distorts the marketplace of ideas by reducing the equal status of some people as opposed to others, therefore the normal argument that you shouldn't issue an injunction in a case involving the media or a film or something of that kind, that does not hold in the context of hate speech. So if a person can establish in an injunction argument, in an interim argument, that prima facie certain channel or program or film or whatever it is has engaged in hate speech in the sense of dignity and equality as discussed, then there are reasons to grant an injunction in a case like that, overriding the normal argument that in free speech cases injunctions should not be granted. Right? Of course, now that really places a heavy responsibility upon the shoulders of the court, whichever court it might be, Supreme Court, High Courts, or so on, to draw a clear distinction between, on the one hand, offense or ridicule, or as the case may be, and hate speech. And one problem is that the existing language of the program code is too broad and too wide for these kinds of distinctions to be properly drawn. So, for example, the very first subclause 6, Rule 6, subclause A of the program code itself shows you what the problem is. It says that no program should be carried in the cable service which offends against good taste or decency. Now, good taste is an extremely subjective, standard. What may be good taste according to me may not be good taste according to you, and we have also, seen that this really changes over time. So, interestingly, I mean, William Shakespeare, who is now considered to be, the greatest English writer who ever lived, and whose plays are now held up as the gold standard in English literature. When he was alive and actually performing his plays, it was actually thought to be very lowbrow and kind of very basic and not really in good taste, many of the things that he did. And now, of course, he's supposed to be the greatest playwright in the history of the world. So something like good taste is really very subjective, and ultimately will depend upon the personal beliefs and prejudices of whoever is enforcing that law, whether it's a court or anybody else. So you can see that, for example, and that's the very first prohibition under the program code. Then you also have, for example, Rule 6M, Rule 6 subclause M, which says that no program shall be carried in the cable service which contains visual or words which reflect a slandering, ironical, and snobbish attitude in the portrayal of certain groups. Now, again, what ironical means and what snobbish means, that's again very subjective, right? And really difficult to pin down. So I think that what this therefore shows is that the constitutional standard that should be applied, and the constitutional values of equality and dignity that prohibit hate speech, there is a gap between the constitutional standard and the actual text of the program code that regulates the media. And therefore, what is in my view required is for the Supreme Court really analyze this program code rule 6 and read it down to comport with the constitutional standards under Article 19 Clause 2, and to actually to reconcile the understanding of hate speech with the present definitions and terms under the program code. Now, one final thing, just for the sake of completeness, I think I've just about crossing around 40 minutes. For the sake of completeness, one final set of cases involve reporting on sub judice matters. Now, there the law is governed by the Sahara versus SEBI judgment of the Supreme Court, which basically says that if there is a well-founded fear that the nature of the media reporting on a sub judice case will influence the outcome of the proceedings, then there can be a ground to impose prior restraint upon the media, because the two rights that are clashing. So in the hate speech case, the two rights are clashing are equality and free speech. In the reporting on sub judice matters case, the rights that clash are fair trial and free speech. So there again, the court must embark upon a balancing exercise between the right to a fair trial and the right to free speech. And after the judgment of the Supreme Court in the RTI judgment of 2019, the test is of proportionality. So you take both rights, right to free speech and right to a fair trial, and then you basically, what the question you have to ask as the court is that if I was to take like X or Y step or restrict the program or restrict the channel, then is it proportionate in the sense that is either right completely losing its value and meaning if this action is taken, and if either right, that is free speech or fair trial, is completely denuded of any content, then that's a disproportionate step that should not be taken. So what that basically means is that if you apply proportionality to the sub judice matters, reporting sub judice matters, what it can justify are narrowly targeted injunctions that specify that certain kind of reporting may not be done for a certain specific time period, but going beyond that will potentially be disproportionate. Although again, after the Sahara versus SEBI case, we haven't seen too many judgments on the point, so the state of law still requires some development, right? So to sum up the position, the statutory regime for regulating the cable TV media is the Cable Television Network Regulation Act. That act requires registration and requires adherence to the program code, failing which the government can take action in prohibiting channels and programs. Now, this raises three potential situations under law. The one that is all good is when everyone works the way they're supposed to work and there is no controversy and the courts don't get involved. A second situation is when the government engages in censorship and overreach under the program code, and then the precedents under the film censorship regime give us the appropriate constitutional standards, whereby the court under Article 19(1)(a) and 19(2) can review the government's actions and strike them down if they overreach. The third situation is when the government does not act and other people have to approach the court saying that the High Court or Supreme Court must step in and ban a particular channel or program in the media because the government is not acting for whatever reason. In that case, there are two situations. One is when you have a full-blown case hearing decision where the court will defer to the executive's initial judgment, but also will engage in an adjudicatory process to decide if the right was infringed or not. The second situation is when an injunction is being asked for, where in ordinary circumstances, the court should be very, very hesitant to injunct a program because of the basic values underlying Article 19(1)(a), with one exception when a hate speech case is at the bar. There a different standard should apply. And of course, it's a very complex process to decide when a case involves hate speech and when not. And in that context, the wording of the program code is probably too broad and requires judicial narrowing down. And the last set of cases involves sub judice matters where there's a clash between rights to fair trial and right to free speech. And there the court should apply the proportionality standard to decide whether, when, and to what extent an injunction should be granted in the case of media reporting on an ongoing case. So that is broadly the outline of what law is and some of the values and principles underlying how we should think about that. And with that, I will stop, and we can have some Q&A for a brief while.
So thank you, Gautam Bhatia ji. I am Professor Suresh Nadgaonkar, Principal of the college. At the outset, I apologize our Honorable Vice Chancellor sir and you and all others, as I could not join on time because of some network issues. So I'm really grateful to you for accepting our invitation and also delivering a very informative and thought-provoking lecture to all of us. And thank you very much on behalf of university and all our
Thank you, sir. Thank you, Gautam Bhatia, sir. That was very informative, enlightening, and thought-provoking, the outcome of which has reached us with a few questions. Sir, with your kind permission, we seek to proceed to the question-answer part of the session.
Shall we take the question answer session later? We'll request our Honorable Vice Chancellor sir to kindly address the students, particularly to give kind guidance to overcome this pandemic, and also on the topic of discussion. And later at the end, I think it is better to take the Q&A. Is it okay, Bhatia ji?
Sure, of course.
Okay. VC sir.
Yeah, thank you very
Yes.
much for giving me an opportunity to actually listen to Bhatia ji. And today we are actually in the midst of the pandemic, very severe pandemic in Karnataka. And so we have started this online courses and lectures, special lectures in Government Law College. I congratulate the principal, Suresh Nadgaonkar, Sudesh Dashta, Satyagowda, Jyoti, and Chandrakanti for their efforts in conducting this program regularly. And I was listening to your talk on Cable TV Act. And that brings me that when I studied journalism, media laws, and the press acts, press laws, which I studied in about 35 years back. And the first press act was actually, you can say, some type of in 1957, when the Vernacular Press Act was enacted within 2 hours, just to gag, and that was called the Gagging Act. And it did not allow anybody to talk or publish anywhere. But today we have social media. In social media with Facebook, blogging, WordPad, social messaging, WhatsApp, microblogging, Twitter, media sharing, Instagram, Wikipedia, video sharing, YouTube. So you can express opinion and you can express anything you want. And I do not know how the media is going to be regulated really this social. You'll see when just somebody is dead and the next minute you'll say it is a fake news. And then somebody already writes a obituary and next person tells you should live long for 100 years. And that's what I have seen in just a matter of hours, how the media takes shape. The media regulations, we say something like gatekeeping, how it should be regulated and who is the person to actually bring about order in this media. It is very difficult in this world where, as Bhatia ji said, you do not know what is right and what is wrong. We have a good taste in William Shakespeare, 500 years back, now says it is very good taste, and at that time it was banned. It is just like Galileo, what Aryabhatta said, the world is round in 450 AD, and then after 500 years when Galileo said earth is round, he was jailed. So you will not know what is good and bad, especially in these laws. And when you talk about hate speech and the Cable TV Act, these are the things which will not bring, there is no clarity. And with subjectiveness is so much ingrained in this, that somebody gives a U certificate, and if somebody goes in some other country, that will be a certificate, and somebody goes to some other country, then it will be banned. So you will have wide diversities of law and the implementation, and we really do not see how we should take it forward. For example, British Board of Film Classification, C stands for censorship, or C stands for classification. C stands for classification. U, A, or above A, or X, double, triple X film, or porno film, we will not know. It depends upon the country where it is actually screened. In 1959, we had Obscene Publics Act. In 1978, we had Protection Act. And in 84, we had Video Recording Act. In 88, we had Copyright Act. In 94, we had Criminal Justice Act. And in 2006, we had Animal Welfare Act. So we are bringing so many acts. And when you try to implement all these acts, I don't think we will be able to release any film. And if somebody is very strict about it. And then similarly, we have Motion Picture Association of America and Pan American. They are trying to introduce their own, standards. And the standards differ from one place to another place. And this cable TV is now become a very gray area, because the people come and have their own groups and their own networks, and what is right and what is wrong has become really a matter of subjective things. And now, what Bhatia ji said in his 40 minutes of this thing, that there are a lot to be discussed. And I am really enlightened by his talk on this cable TV. And media laws is a wide topic. You can go on, you can have a degree and postgraduate degree in media laws. And I do not, they do not have takers for that immediately. But probably in future it becomes very important, especially in the realms of cyber crimes and social media and all other type of media, which is now in the forefront. And especially if you see this pandemic situation and the media, it really requires media laws. And thank you, Gautam Bhatia ji, for your enlightened and erudite lecture. And I thank the Law College for its effort in bringing special lectures to University Law College, and congratulate Suresh, Dasrath, Satish, Jyoti, and Chandrakanti for their effort in conducting this program effectively and efficiently. Thank you one and all. Namaste.
Thank you, sir. Sir, can we move on to the question answer session now?
Definitely.
Participants can send in their questions in the chat room to Ms. Hita. So the first question is, does media regulation...
Satish Gaura sir has a question, ma'am. Could you please recognize him?
Yeah, thank you. Sir, it's a wonderful lecture. Thanks for throwing discourse on media and constitution laws. And sir, in fact, no doubt, media has been playing significant role in a democratic setup to uphold constitution values and principles. And as far as print media concerned, okay, some extent it is fine. They are following at least the objectives mentioned under Article 19, Clause 2. As I have seen, they have filed so many defamation cases even against print media. Somehow there is some small regular, as I told you, even when I was in Mysore, what junior division, civil court junior division has power, even press council doesn't have. Why? Because if you go to the civil judge junior division, you can get injunction under Article 39, Rule 1 and 2. But if you go to press council, I think it's very difficult. In the same line, I have a question when it comes to the visual media, especially news channels concerned. Indian judiciary, in its exercising suo power in its judicial activism, has done a wonderful job in the case of environment, in protecting the rights of vulnerable sections. When it comes to the case of visual media, that to news channel concern, judiciary suo could have imposed so many restrictions in the form of guidelines. When when the channels telecast news or any program, which are against to the objectives of Article 19, Clause 2. Why till the date judiciary has not shown its judicial activism? Why there is a judicial passive, in the sense passive approach by the judiciary to regulate this news channels? And because today you have witnessed during this pandemic, they have been telecasting many things. They do not have any authority. Taking into a public interest, as a matter of public interest, judiciary could have laid down so many guidelines. Why? What are the reason? What is the reason judiciary has not come forward till today to issue some guidelines in a positive way to ensure proper coordination work? And one more question is, like press council, why can't we have television council? Because press council alone cannot look into all the issues. Even there is no specific term what you have used in the case of the cable television network regulation act 1995. So what is your opinion in this?
Yeah, no. Thank you for these two questions. I think the second question is the easier one to answer, which is that I think it's very important that that the body on the lines of the press council exists. Because at least for these things, in the first instance, the self regulation is the best way to go forward. And the Supreme Court had suggested something to that effect during the hearings involving the Sudarshan TV case last year, but it hasn't yet happened. But I think that it's something that people should raise a demand for, body of similar kind that helps in having a structure in place for self-regulation, at least in the first instance. Your first question about judicial guidelines. Now, I'm somewhat skeptical about judicial guidelines because they often create more problems than they solve. Specifically for something that requires a case-by-case approach, as these kinds of cases do. So the problem is that much like the program code, if you lay down in advance a range of guidelines, then anyone who really wants to can find a way around them, can find loopholes to them, and people who are genuinely doing genuine work often get trapped because some busybody will file a PIL saying that so and so is doing X or Y. So I think that it's actually a better way to go is to incrementally develop the law through specific cases. So when a case comes before the court that X channel or Y program has specifically violated this law, or this legislation, then the court can use that to lay down principles, that these are the underlying values or principles, and developing it through a case-by-case basis, in my view, would be a safer route to take than at one specific point saying these are like 10 guidelines that kind of henceforth govern the field. So but this is of course like a question for discussion, and this is only my personal view on this.
Thank you, sir. Thank you.
Sir, we have another question. Does media regulation directly curb the democratic principle of dissent?
No, it depends entirely upon the structure and the form of the regulation. So if you look at, so I said earlier, if you look at the present wording of the program code, right, then there is a lot of potential or risk there for the curbing of dissent. So as I said, just look at the first the Rule 6A, anything offends against good taste or decency. So if you start citing what in your view is decent and indecent, and what is in good taste and in bad taste, then that is a direct route to curtailing dissent. So it depends on how you frame it. On the other hand, if like for example, the Canadian Supreme Court judgment that the Pravasi Bhalai Sangathan case in India relied on, where you kind of narrowly define what hate speech is, and you specify that the reason why you need to regulate, say, hate speech is because there are other constitutional values like equality and dignity that have to be balanced against the right to free speech and similarly right to fair trial. Then in that case, it's not really a curtailment of dissent. Then that's simply ensuring that the number of rights that the Constitution guarantees are all equally protected. So I think that it really turns on what you are regulating, how you're doing it, and what the structure is. And like I said, for example, if the court starts granting injunctions like left, right, and center uh, under the Cable TV Network Regulation Act, and then that ultimately does lead to a stifling of dissent. But if injunctions are not ordinarily granted, only in extreme cases like hate speech, then you again have found the right balance. So I think that, yeah, as I said, it depends on the nature of the regulation. Not all regulation is curtailing dissent. But some kinds undoubtedly steps into that territory as well.
So we have another question. Is there a necessity to increase regulations in news media, considering them becoming houses of personal opinions and party-sponsored propaganda?
No, so I think that the answer there is not the answer there is not so much to regulate or to restrict, but to ensure that everyone has an equal platform. So I think that there are two things. One is that, okay, so there are some circumstances, like, for example, if you're inciting violence or inciting a riot, or if you are engaging in other kinds of hate speech, public disorder, then of course you have to kind of go and impose restrictions or bans or regulations at that point. So that's fine. But I think but when you're referring to like deeper structural issues about how the media behaves, then the solution has to be as structural as well. So, for example, there used to be in the US, there used to be something called the Fairness Doctrine, which meant that if a TV channel basically put out the view of one like politician or like one political figure, then they were by law obligated to also carry the rebuttal by the opposition or the opposite party or the opposite or whoever person it was who was being attacked by that first person. If you look at rules for election coverage in, say, the UK, in England, so they have this like really strict set of rules that requires the media to give equal airtime to all the political parties. So I think that if you have that kind of structural regulation that ensures that everyone has equal access to the media, is a better way of going about things than content regulation saying that you can't do X or you can't do Y. So I think that's the balance that needs to be, I think, envisaged.
Participants are allowed to raise their hands if they have any questions. Sir, I'll recognize Shreyas.
Well, hello. Good evening, sir.
Hi.
Good evening, sir. I am asking this question with a bias. I feel the government is a bit authoritative in this thing. OTT regulation, where government has stepped in to regulate OTT media. Few words by you on what are the things which would, few words on it, sir. I mean, how it goes against the given laws or constitution, regulation of OTT media.
Yeah, that's a really good question. And
I'm asking this with a bias. I feel the government is being authoritative and it's kind of being trying to control everything.
No, this is a really good question, but unfortunately, I can't answer it because I am in part of the case that is in challenging the OTT regulations, assisted with drafting the petition. So I shouldn't be publicly expressing an opinion on it. What I would suggest is that the Internet Freedom Foundation and the IFF has some very excellent analysis of the OTT regulations on their website. And I agree with their views. So if you check that, that's what I would recommend. But because I'm involved in the case, I think I shouldn't on a public platform express legal views on that.
Well, thank you, sir. Thank you for answering my question. One thing I have to say, I happen to follow you on Twitter. I read your articles on Indicon Lawful WordPress, and I happen to read your articles along with Surit Patsarthi on Hindu columns. I follow you on Twitter. you are one of my go-to person for referring any judgment, be it the latest one on Maratha Supreme Court reservation. I happen to read that article also. Thank you, sir. Thank you for providing me this opportunity. That's
Thank
it.
you. Thank you so much. Thank you.
Next, I recognize Faiza Khan. Please ask your question.
Okay, thank you, Meghna. Firstly, I would like to thank Gautam sir for his wonderful lecture. So my name is Faiza and I'm in the final year. So my question is pertaining to the media trials that took place last year with respect to the Riya Chakraborty case. So what do you think, sir, like when the media actually stages such kind of telecasts, which actually already portray the person to be someone who is not even I mean, he has not yet been found, she has not yet been found guilty, but still is being seen as guilty. So in those cases, how do you think the media can regulate and try to curtail itself to not take forward media trials like that, especially even in cases where anybody who is expressing dissent is categorized as an anti-national, or they are already, labeled as certain things before they can even get a chance to, put forward their case. So what do you say on those instances, sir?
Yeah, so I think that these two falls, the Riya Chakraborty case and other cases you mentioned, I think fall very squarely between squarely within the two examples that I talked about, which is hate speech and fair trial. And those are the exact cases where the court has said, and rightly so, that there are good grounds for an injunction to be granted to prevent media programs or broadcasts that either interfere with a trial, and of course that includes even starting with accusations about guilt even before the person is arrested, and the kind of persecution or demonization that can open up a person to violence or other kinds of discrimination. I think that the example that you've taken actually, I think, falls very squarely within the narrow set of examples or instances where a court should be justified in granting an injunction, against a programmer. So I don't think self-regulation will. Those are cases where self-regulation can't really solve it. Like you actually need a judicial intervention to ensure that other people's rights are protected as well. And I think that, of course, in the longer term, people who are subjected to these kinds of attacks have other remedies like defamation, breach of privacy, and so on, under tort law, civil law, and so on. But given the amount of time that those kinds of proceedings take, these are cases where I think injunctions are justified.
Sir, now to just follow up with whatever you were saying, sir, if I may ask you another question.
Sure.
So it is with respect to expressing the dissent. When a person even raises any points of criticism towards the government or anything, then sedition law is applied like so interchangeably always in any case that it feels like it kind of hinders freedom of expression in that way. So sedition or UAPA, for that matter, for just raising slogans, in which last year we had a student activist who had raised certain slogans, and she was heavily criticized all throughout the media. She was branded as a person who is a traitor to the country and all of that. So in that way, so what do you think, how do you think we can have some overlook or some oversight from the judiciary on such instances?
Yeah, I mean, so I think that it's very clear that there are a set of laws that effectively are examples of what is the Supreme Court in Chintaman Rao's case called overbreadth, which is that their wording is so broad that they cover not only illegal speech, that is speech that leads to public disorder, but also completely legal speech, right? And I think that there is a very straightforward answer there, is that as long as these provisions remain on the statute books, it's not even that they're being misused, they're just being used as their language allows for them to be used. So until sedition and something like section 10 of the UAPA stays on the statute books, these kinds of incidents will continue, and I think that therefore until the court strikes some of them down and reads some of them down, that is the only long-term solution. But that's a problem that's kind of been there. I think from the beginning of our republic, where in 1962 the Supreme Court upheld the constitutionality of sedition, and it was often used in those times to, in fact, go after even former freedom fighters by the new government. So this has been a long-standing issue, and I think that until the laws that enable this to happen are not removed, it's very difficult to, in individual cases, then prevent people from being sent to jail and being in jail for a long time before even a trial commences. Because as you know, in most of these cases, ultimately people are bailed out and ultimately found innocent. But it's just the process that effectively becomes to use the old cliche, becomes the punishment. And so I think that, and the only solution there is for these laws to be taken out in some way.
Dhwani Nagesh, please, you could please ask your question.
Hi, sir. I'm Dhwani. And my question is, today the social media platforms on several accounts are being utilized for spreading hate speech, not only by the general public, but also by the political parties across the country. And in this particular scenario, isn't it time to examine the accountability of these platforms and also the freedom given to these platforms to regulate hate speech?
Yeah, this is a really good and complex question that has no straightforward answer. So I mean, you're obviously right in the sense that the influence exerted by platforms such as at least, I mean, so WhatsApp is, like, of course, like, not a public platform, so it's different set of issues. But platforms like, say, Facebook, Twitter, Instagram, and so on, the influence exerted by them has ramifications in the offline world, and effectively they have become, if not state entities, but they play public. I mean, they are public effectively in their impact. They are public bodies and therefore required to be held to public law standards. So I think that is so I think that it's absolutely true that there has to be, like, regulation of these entities, because it can't be that Twitter's terms of service and Twitter's enforcement of it ultimately becomes the final deciding point. And the common argument made is that Twitter is like a private company, so therefore they decide like what happens on Twitter, and so it's ultimately their discretion who stays on and who gets kicked off, which is legitimate. But when private bodies achieve a certain scale, they're no longer effectively private, and definitely these bodies, in the impact they have, are not just private bodies. So I think that they should, so these bodies then should be, I think, held subject to 226 proceedings, and you should be able to subject them to writ proceedings and subject them to public law standards of non-arbitrary behavior, respecting fundamental rights, and so on. But I do think that the structural issue is something that's been often raised in the US now, not yet in India, which is that it's really important to break up these big tech giants, because ultimately, if these social media platforms enjoy a kind of monopoly over discourse, then the attempts to regulate them will be extremely hard. So much like in other domains, you break up monopolies into smaller component parts. Entities like Facebook and Twitter and so on need to, and Twitter maybe less so because it's still not that, the penetration is not that great. But something like Facebook has to be, like, basically broken up and into multiple smaller component parts, and so big tech should not enjoy these kinds of monopolistic powers to just, like, influence the discourse. So I think that's the longer term structural solution, and the shorter term is, I think, as you say, Indian jurisprudence needs to develop in a way that you can use Article 226 and you can use writ proceedings and subject these bodies to public law standards and to comply with those standards.
Sir, would you take up one last question?
Sure, sure.
Sir, has media trial become a threat to judicial system in India?
See, I don't know. I mean, I'm not sure. It's definitely become a threat to people's lives and physical security. So, I mean, that's one thing. Judicial system, I don't know, because see, in the 1970s we abolished the jury system, right? And we abolished the jury system precisely because of the Nanavati case, where the media basically drummed up sympathy for the accused, and so the idea was that judges are not supposed to be, a judicially trained mind is not supposed to be influenced by whatever the media is saying. But at the same time, I mean, like it's also true that judges are human beings, and judges don't live aloof from the currents of society. And so it's, I mean, if the media is really going after somebody like left, right, and center, 24/7, then it's hard to see how judges can remain unaffected by that. So I think that maybe I don't know if it's already affected it or not, but I think the potential to affect it is definitely there, and it might make sense to perhaps do an empirical analysis and see that, is it the case that certain terms or phrases that are being used in the media about like a specific person or a group, do they find their way into judicial discourse and judicial orders, or in like kind of arguments in court? Are judges kind of unwittingly reflecting those kinds of terms? And if that kind of empirical study is done, then maybe we have a better idea about what actual influence it's having on the judicial process. So I do think that, yeah, I think the potential is there, although it's not as grave as if you had like a jury system.
Thank you, sir, for answering all the questions patiently and with such conceptual clarity and analysis. I'm sure the participants have made the most out of this session.
Yeah, thank you so much for calling me.
As we come to the end of today's session, I request Ms. Navodita, student of University Law College, Bangalore University, to propose a formal vote of thanks.
Thank you, Meghna. A very good evening to one and all present here. I, Navodita KM, on behalf of University Law College and Department of Studies in Law, Bangalore University, take immense pleasure and privilege to render the vote of thanks on this special occasion. Firstly, I would like to express my immense gratitude to our special guest, Shri Gautam Bhatia, advocate and legal writer, who, despite his very busy schedule, took the time to deliver a special lecture on the topic, a constitutional approach towards the media regulations, in the ULC special lecture series. Thank you, sir, for sharing your valuable insights. I'm sure all the participants will reap the benefits of this lecture. I would like to express my immense gratitude to Professor Dr. K.R. Venugopal, Honorable Vice Chancellor, Bangalore University. Thank you, sir, for gracing us with your presence and constant support in all our endeavors. I would like to thank Professor Dr. Suresh. I would like to thank Professor Dr. Suresh V. Nadagaudar, Honorable Principal and Chairman, University Law College and Department of Studies in Law, Bangalore University. Thank you, sir, for your unwavering support and guidance. I would also like to thank Professor. Thank you, sir. I would also like to thank Professor Dr. N. Dashrath, Dean in the Faculty of Law, Bangalore University. Thank you, sir, for your support and guidance. I would like to express my heartfelt gratitude to all our faculty members. Thank you for your instrumental support and guidance. In these challenging times, you have been the flag bearers of fostering education at all levels. I would like to express my humble thank you to our student organizing committee for their continuous efforts and hard work despite these extremely challenging times. I would also like to extend my heartfelt gratitude to all our participants for turning up in large numbers and making this event a grand success. Once again, thank you one and all.
Thank you, Navodita.
Thank you.
Thank you,
Okay,
sir.
thank you, Bhatia ji.
Thank you so much.
Yeah, thank you, and we'll bother you for many more such interactions with our students in the days to come.
Of course, hope to meet you in person sometime. Bangalore is a city I love, so hope to see you in person sometime.
Whenever you are here in Bangalore, you please make a visit to our institution.
Yes, of course.
They are in our campus, Bangalore University campus. Yeah, okay. So I thank Professor Sudesh sir and Dashrath and all our faculty members for gracing the occasion, and all our students, despite, of course, today is a holiday, but otherwise also whenever we organize such special lectures, all of them will attend despite attending 5 to 6 regular classes. They are all very enthusiastic and interesting in having all interest in such activities. Okay, thank you very much.
With this, we conclude today's session. I'd want to thank University Law College and Department of Studies in Law, Bangalore University, for giving me this opportunity to host this session. Stay tuned for future lectures. Thank you one and all. Stay home, stay safe. Jai Hind.
Okay. Thank you, Meghna, for very nice comparing. I thank all the organizing team. Thank you very much.
Thank you, sir.
Thank you
sir.
so much, Gautam sir. Thank you so much.
Thank you, sir. Bye, sir.
Host, you can end the meeting.
Oh, so I'm ending the meeting.
Thank you, sir. Thank you, everyone.
Stop live, Raghavendra.
Yeah.